When a person or business holds the trade secrets, others cannot copy. Securing the correct protection for your property is very, very important, which is why consulting with a lawyer is a must. Whenever we talk about science, there are hundreds and thousands of questions that keeps on coming in our mind. Trademark can be held as long as possible. They do not have a death. Good morning and welcome to the first session in Unit 4 Commercial Law, where we are going to speak about the intellectual property rights. Now, one of the biggest rights that you can ever think about, or one of the biggest possession that a man can ever think about, is his own innovation. Every day, every minute of our life, we are filled with surprises, we are filled with innovations and discoveries. But do all these things are properly patented? Do you really get the credit for what you have done? That is a very big question that comes in the mind of every single human being. Why? Because when we talk about this intellectual property rights, they are the rights given to the people over the creations of their mind. Using your knowledge, you are able to create a car, you are able to create a plane or a train or a mobile or a laptop or any other technology that is beneficial for the mankind. But then it is very, very difficult whether you get an intellectual property over it. It's because your property, it is a value, it is an accreditation given to you. So that is where IPR comes into picture. They usually give the creator an exclusive right over the use of her creation for a certain period of time. So the IPR council gives that right to the owner to use that product exclusively for whatever purpose over a period of time, because that is his or her innovation. That is his or her hard work in terms of coming forward and doing that particular activity. So the IPR, the intellectual thought process that has gone inside in terms of creating it and doing it, will make you to get a bigger reward in the long term. That's why the council says very clearly, intellectual property right, the right should be given, the beneficials right should be given to the owner, that is the person who has founded it out, for a certain amount of time. Followed by the 4 types of intellectual property is what we are going to see today. So when you talk about that intellectual property itself, you start getting that feeling, you start getting that factor that yes, it belongs to me. I am the leader, I own it, and I should have the rights in terms of enjoying it. So that's where this intellectual property comes into picture. Now let's think about it. There are 4 types of intellectual property rights and protections that, although there are multiple types of intellectual, we are thinking about it. Securing the correct protection for your property is very, very important, which is why consulting with a lawyer is a must. There are 4 categories which we are going to see today. Now, whenever you invent something new, whenever you see that that invention has got some potentiality in the market, you have to secure it. Not for the reason trying to become selfish, but for the reason that it should not get into the hands of the wrong persons. So you should ensure that each and every factor of your innovation, invention should be put in proper place so that you are getting the maximum benefits out of it. So there are 4 categories which we have to understand. And before, when we go for this intellectual property right over a particular product or service or innovation you have done, you need to consult a lawyer and go through it legally in terms of securing it so that you are able to enjoy the benefits of it in the coming years. Now, moving further, let's try to talk about the 4 types, which includes trade secrets. Now, what are trade secrets? Trade secrets refer to specific private information that is important to a business because it gives a business a competitive advantage in the marketplace. Now, for this, I would not go further ahead than the KFC, the Kentucky Fried Chicken. They have a special recipe which they keep it as a secret. They don't want to give it to the public because that gives them a competitive edge in the fast food market. Similarly, the McDonald's doesn't want to share their secret, nor the Coca-Cola would share the recipe of the cola concentration. Now, these are all the business secrets that an individual organizations hold it because they feel if the secret is out in the market, everybody will try to replicate it and they will lose the market share. So it is very important that how we maintain the trade secrets. Every business like that, be it be a technology oriented, a robotic oriented, a chemical manufacturing, banking, whichever might be the line of service that we are talking about, each of these companies will have their own trade secrets. They don't want to give away the secrets for free because that is not what is expected. That might not fetch them any edge in the market. So they try to keep it in a particular level, in a particular place, in a particular manner so that they always stand unique in terms of the service delivery. Now, if a trade secret is acquired by another company, it could harm the original holder. That is very, very important. Moment when we talk about China, quite obviously, most of us know that China is known for copying its products, copying the products of other company and releasing a makeover of it. There is nothing harm in terms of, I'm not trying to degrade or I'm not trying to put them down, but the ideology of the Chinese method is that they immediately try to create one more version, a fake version, a duplicate version of the original product and dump it across the world. Now that should not happen at any point of time. Why? Because the original owner, the inventor, the founder should get the maximum benefit for what he is doing. It should not be in such a way that only this person is able to enjoy it, only this person is able to take over the entire advantage. It should actually go to the business owner who has put in his hard work, sweat and effort in terms of making up that product. So that's where intellectual property right in the form of trade secret says that yes, you will have the right to safeguard it and not let it out in the market by which it might cause a harm for you. Now, examples of trade secret includes all the food and beverages like Mrs. Fields cookie or Sprite or Coke, or all those people are into this because that is where you get a cutting edge technology altogether. So it's mandatory for all of us to understand that the concept of trade secrets is very, very important as you go through a business. Now, let's also look into this case factor where we are going to talk about how the trade secret comes in terms of the IT companies also. Whenever you listen to the name of those big IT companies like Cisco, IBM, Microsoft, or you're going to talk about IBM, Honeywell, or you're going to talk about companies like Infosys, TCS, Reliance, all those big kind of companies which are involved in the technology related business, they all try to keep their service delivery model as a secret. And that is their trade secret. The way how they approach the client, the way how they service their client, the way how the metrics are being drawn and how they are able to create a margin for themselves is an absolute secret. They in fact take a non-disclosure agreement on these terms. Why? Because they don't want the other companies to just copy their model and go and pitch outside. That is not expected at all. That cannot be taken into account at all. What we want is that whether you are a technology-oriented company or a financial-oriented company, service-oriented company, whatever it might be, but what we are interested here is that we want to see whether you are able to retain your secret and grow well with it. So the more you are able to contend, hold it in terms of your intellectual property, the business is able to propel faster and in a secure manner. Followed by, when a person or business holds the trade secrets, others cannot copy. That's very, very important. These days, whenever we hear about any information, you immediately spring back saying that, well, that was already told in that page, in that website, in this link. The reason is that it's very easy for human beings to just cut, copy, paste and put things. We do not want to waste time. Most of us have become so lazy that we don't want to think further and do the job. We only want a ready-made instant answer for every single product or service that we are talking about. So what we intend to do, how we intend to take care of this is that we just take forward anybody's idea, copy paste it, and just establish an information altogether, which creates a trade secret. Now, in order to stop us from all this, the legal protection associated with the trades, the businesses must behave actively in a manner that they demonstrate their desire to protect the information. Now, nobody will come forward to help you to protect the information wantedly. It is the responsibility of the company itself to look into it and protect the intellectual property rights, which means to say that it is very, very important, the need of the hour is in such a manner that they should be able to see it without even getting into any troubles or any format. They should be able to protect it. They should have the highest standards for retaining that secret and take it forward in such a manner that they are able to build a successful empire out of it. That is why I always say it is mandatory for companies to maintain their trade secret. Followed by the trade secrets are protected without official registration. However, an owner of the trade secret whose rights are breached, if, for example, that is someone steals away their secret, may ask the court to go against that individual to prevent the use of them. Now, what happens is that the biggest part of our life history is that man always wants to try out the secrets, pull it out and make it public as far as possible. We are never happy or we are never contented in keeping a secret to ourselves. Moment we know that somebody has got a secret, somebody has got an inner strength, realization, we want to break it open. We want to make that secret a public talk. So, in the same manner, whenever a company is trying to make its trade secret a patented form, it is a secured form altogether. But then there are people who want to steal on that particular act. They want to remove it. They want to take it away and make a public use of it, make a maximum benefit of it. In that case, the company can go against the person using a legal action and prevent him from using that technology altogether. That is what we typically talk about the trade secret. Patents, the next form that we are talking about. As defined by the US Patent and Trademarks Office, the USPTO, a patent is a type of limited duration protection that can be used to protect inventions or discoveries that are new, non-obvious and useful, such a process, machine, article, or any composition of matter. Now, science is a big marvel to the mankind. Why? Because whenever we talk about science, there are hundreds and thousands of questions that keeps on coming in our mind. Whenever you look at the sky, the stars, the moon, the sun, every kind of thing is a question mark. Why? Because that's how science has evolved with us. Science makes you think. Science is filled with logic. So what happened for every scientist? Science is a boon for them to do research more and create something new every day. But how are we going to protect those new inventions? Is there a methodology by which you can hold it to yourself for a limited period of time, for a given period of time, and create a name for yourself? It is not just about making money. Please understand that patents are not just about making money. Patents are about a recognition, a reward to the hard work that has gone in by that scientist or by that person who has discovered a new metal, who has discovered a new technology, a new process, new composition altogether. So which means to say that that person should be given due recognition for his hard work. That's where the patents comes into picture. So when a property holder holds a patent, others are prevented under law from offering, sale, making or using of the product. So there is a patented mark, a trademark that comes into picture. So whenever you look into Mercedes-Benz, they have a nice pointing tri-star. Now that is their patent mark, trademark altogether. You cannot use it anywhere else. That property, that rights belongs only to the Mercedes-Benz brand. So similarly, everybody who are trying to invent on their own and who are successful enough about their invention will go to the patent office and file it. Once the patent is being filed, then automatically the other people, the common people, cannot go about and use this patent for their right. Why? Because under the eyes of the law, it is considered to be illegal to do such kind of acts. So that's why we say very, very clearly here that the law tries to protect people from using or making any unwanted usage about it, followed by copyrights. Now we are going to talk about the third kind. The copyrights and patents are not the same things, though they might look often similar and get confused. So let's first try to understand what is a copyright, and we also know what is a patent. A copyright is a type of intellectual property protection that protects original works of authorship. Very, very important, guys, which might include a literary work, music, art, and more. Definitely, yes. Today, copyrights protect computer software and architecture. The protection that is given to the original work, authorship, which might include music, art, science, and all those kind of factors. So copyright is more about protecting the originality of the work that has been undertaken. So let's say that I write a book in economics and I have a copyright over it. So the contents that I have created in that book, the copyright belongs to me. In the case, I can go ahead and file a case if somebody takes it against to be on the copyright. If somebody copies it, somebody tries to make my material as their material, then I can go ahead and file a case against them. These days, even software products and the architecture that has been done comes under the copyrights altogether. Now, how does a copyright protection comes into picture? They are automatic. Once you create something, it is yours. They are automatic because it is created by you, so automatically the rights will go to you. However, if your rights under copyright protections are infringed, now what do you mean by infringed? Which means it is being taken up by someone and you wish to file a lawsuit here, then the registration of your copyright will be necessary. So in that case, only when you find that this kind of a particular exercise is now being infringed, it's now being taken into position, it is creating something which can actually be, a problem to the situation, a problem to the entire scenario altogether, then you can go ahead and show the registration copy by which the copyright can be protected. Trademarks. Finally, the fourth type of the intellectual property is the trademark protection. Now, what is this trademark all about? You might have seen a lot of trademarks in your life where it has been stamped on the product, it has been put there. Now, that is one of the most biggest form of trade protection that we are talking about. Why? Remember, patents are used to protect inventions and discoveries. Copyrights are used to protect the expression of ideas and content, whereas trademark is offers to protect the phrases, symbols, or the jingles that have been there. When you see this symbol, Nike, if I might just draw it for you, this is the Nike symbol altogether. Now, nobody can take this logo and put it somewhere else and claim that it is Nike, because it is Nike's trademark. Similarly, for Adidas, for a Puma, or for a Reebok, they have their own trademark symbol which identifies them in the crowd. So what is happening here is that these are all certain phrases, symbol, like when Nike says, just do it. Now that is their trademark phrase line, where they say that that's their, the line which actually distinguishes them and tells that what is their existence all about. So whenever we talk about this trademarks, that is the symbol that will distinguish the source of a product or services of one of the party from another. For example, the Nike symbol, which is nearly all, could be easily recognized and identified as a trademark. So that is what we have been able to speak about. We are able to tell all together. So that's where I come back and I say that this factor very clearly, that trademarks are going to create a very, very important presence in the modern day world. So whenever you see a trademark which has been registered, which has been patented altogether, that belongs to a particular scenario. Now, nowadays, what is happening is that every logo, every symbol, or every kind of act has its own value, has its own name and situation. So you cannot just copy it and put it yours. So tomorrow, let's say that you are going to create your own app. You are going to create your own idea with a logo, with a jingle, with a phrase. That purely belongs to you. You cannot claim it from anybody else. You cannot say that that is out of the thing. So you are a person who's creating things by yourself. So that's why we call it as something as a trademark, which holds the phrases, the names, the jingles, and the symbols together. Now, while patents and copyrights can expire, they can definitely expire, trademark rights come from the use of the trademark, and therefore they can be held indefinitely. Now, that's a very, very important word, which means to say that trademark can be held as long as possible. They do not have a death. Like copyright registration, a trademark is not required, but registering can offer additional advantage. You don't have to register because it is automatically done, but still, if you register the trademark under the particular office, then you will have additional advantages. Now, an intellectual property protection is critical to fostering the innovation. That's very, very important. Without protection of ideas, businesses and individuals would not reap the full benefit. So it is very, very important that the businesses and the factors reap the full benefits of their inventions and would focus less on research and development. They should not try to work more towards the research, and in terms of, going away from the research and development, they should try to focus in terms of building up a better situation. See, for example, if you see, most of the companies these days spend a lot of time, money, and energy in creating a very, very specific, unique product. But unfortunately, those products do not sustain in the market because there are people who will just go and rule over it, make a copy of it, sell it in the market at a very cheap price. So that's where the intellectual property gets completely destroyed. So whenever people create the product, they should go and claim their intellectual property right. Similarly, artists would not be fully compensated for their creations, and cultural vitality would suffer a fall. This is why the trademark factors, the copyright factors are very, very important. With this, I come to the end of today's session. I hope and believe that all the information that has been shared here will be of a great value and resource to you. In the upcoming sessions, we shall learn more about the factors of copyrights and the intellectual property rights. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.